Hey everybody, this one is about how all state taxes for U.S. citizens cestui trusts slash slaves. Um, so an excise tax is a privilege tax. An excise tax is a tax imposed on the manufacture, sale, or use of goods, such as a cigarette tax, occupation, or activity. The requirement of the payment of such taxes is only a mode of licenses is only a mode of imposing taxes on the licensed business, and the prohibition and the penalties against carrying on the business without the license is only a mode of enforcing the payment of such taxes. Okay, so this is what they're talking about is excise taxes, the recognition by the acts of Congress of the power and right of the states to tax, control, and regulate any business carried on within its limits. Okay, so businesses are really all they're supposed to be taxing. This is the license tax cases, and an excise tax is a license tax, okay? Such as a license tax or attorney occupation fee, okay? An excise tax is a privilege tax. A license tax is a privilege tax. Anyways, a license is a contract. It's a right given by some competent authority to do an act without which such authority would be illegal. The instrument or writing which secures this right is also called a license. A license is express or implied. An express license is one in which, in direct terms, authorizes the performance of a certain act, as a license to keep a tavern by public authority. An implied license is one which, though not expressly given, may be presumed from the acts of the party having the right to give it. In other words, when you pay filing fees in one of their kangaroo courts, okay, that's an implied license. It's an excise tax. If it were true that, according to the spirit of our Constitution, the power of taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, and excises within this district. If the principles of liberty in our Constitution forbid the raising of revenue from those who are not represented, do not these principles forbid the raising of it by duties, imposts, excises, as well as by direct tax? Okay, that's again the U.S. Supreme Court. The government can only tax its own property. Okay, in other words, Dominion legislation, even though it deals with Dominion property, and that's a Canadian case, but there's consistent stuff in the U.S. too. The point I want to make here is this is the same. These are fundamental principles of law. It applies in Canada. It applies in all countries. This is the U.S. The Congress shall have power to dispose and make all needful rules and regulations respecting a territory or other property belonging to the United States, okay? And that's what they tax. They tax their property. That's the U.S. Constitution, Article 4, Section 3, Clause 2. The taxing power, being in its nature unlimited over the subjects within its control, would enable the state governments to destroy the above-mentioned rights. And if they can take a penny, they can take it all. Okay, you got to understand what's going on. If they can take a penny, they can take it all. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may also be pronounced as self-evident. Okay, it's obvious. The sovereignty of the state extends to everything which exists by its authority or permission. And that's McCollum versus Maryland, U.S. Supreme Court, 1819. And this is an act to impose taxes in commerce only at George III, Chapter 12, 1778, only 2 years after the Declaration of Independence. Whereas taxation by the Parliament for the purpose of raising a revenue has been found by great experience to occasion great uneasiness and disorders, well, no joke, Batman, that from and after the passing of this act, the King and Parliament of Great Britain will not impose any duty, tax, or assessment whatever payable in any of His Majesty's colonies, provinces, or plantations in North America, except such duties as it may be expedient to impose for the regulation of commerce. This is the definitive Treaty of Peace of 1783, which was approved at Paris. It having pleased the divine providence to dispose the hearts of the most serene and most potent Prince George III, King of Great Britain, France, and Ireland. So he's King of England and France. That's kind of interesting. He's basically financing both sides of the War of Independence. And it goes on. Arch-Treasurer and Prince-Elector of the Holy Roman Empire and of the United States of America. And so he's arch treasurer. I mean, they don't put stuff in there that's not material to the particular issue at hand. Okay, so they're putting it in there because they used Roman cult money basically to finance the War of Independence. And so it was the Roman cult that was behind the whole thing. Arch-treasurer and Prince-Elector of the Holy Roman Empire, and he's also Arch-treasurer and Prince-Elector of the United States of America. And that means that, I mean, they go and they've been running things right from the beginning. King George signed the definitive Treaty of Peace of 1783 as King of England and France. King George signed the definitive Treaty of Peace of 1783 as Arch-treasurer and Prince-Elector of the Holy Roman Empire and the United States of America. And what that means is King George financed both sides of the War of Independence with Roman cult money. And King George, with cooperation of the Roman cult Jesuits, deliberately created the circumstances for the War of Independence. That's exactly what happened. And then plus, he's been running the United States of America ever since. This is Eisner versus McComber, U.S. Supreme Court. It becomes essential to distinguish between what is and what is not income, according to the truth and substance, without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution, from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Here we have the essential matter, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of an exchangeable value severed from the capital, however invested or employed, and coming in being derived, that is received or drawn by the recipient for his separate use and benefit and disposal. That is income derived from property. Nothing else answers the description. And so the point being is that it's corporate profits is what it is, okay? And I would also like to say that where it's underlined, it's also bold, and that was in the original, okay? And if you go look it up in a law dictionary, or law book, I should say, you will find that it's exactly how it shows it. Slater's protestations to the effect that he derives no benefit from the United States government has no bearing on his legal obligation to pay income tax unless the defendant can establish that he's not a citizen of the United States. The IRS possesses authority to attempt to determine his federal tax liability. So this is all for U.S. citizens, or resident aliens, actually. An act to provide increased revenue from imports to pay interest on the public debt and for other purposes. This is located at 12 Stat 292, August 5th, 1861. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. Section 9, which is 12 Stat 296, it's 4 pages later. Be it further enacted that for the purpose of assessing the above tax and collecting the same, the President of the United States be and is hereby authorized to divide respectively the states and territories of the United States and the District of Columbia into convenient collection districts, and to nominate and by and with the advice of the Senate to appoint an assessor and collector for each such district, who shall be freeholders and resident within the same. Section 10, and be it further enacted that before any such collector shall enter upon the duties of his office, he shall execute a bond, right? So they have to be bonded. Section 49, be it further enacted that from and after the first day of January there shall be levied, collected, and paid upon the annual income of every person residing in the United States, whether such income is derived from any kind of property or any profession. Okay, so this is the income tax, okay? And you need to look it up. Section 51, and the several collectors and assistants may, if they find no property to satisfy the taxes assessed upon any person, and which such person neglects to pay, shall have power, and it shall be their duty to examine under oath the person assessed under this act or any other person, and may sell at public auction any stocks, bonds, or choses in action belonging to said person. And in case he refuses to testify, the said several collectors and assistants shall have power to arrest such person and commit him to prison. See, that's where the debtors' prisons came in, right? And to be held in custody until the same shall be paid with interest thereon, and a place of custody shall in all cases be the same provided by law for the custody of persons committed for any cause by the authority of the United States, and a warrant of the collector shall be sufficient authority to the proper officer of the receiving and keeping such person in custody until the amount of said tax and interest and all fees and the expense of such custody, okay, so it's a debtor's prison, shall be fully paid and discharged. This is 12 Stat. That was 12 Stat, chapter 45, August 5th, 1861. This is chapter, looks like 119, July 1st, 1862. Okay, and this is, if you look back on this other stuff, some of it's been repealed. But anyways, an act to provide internal revenue to support the government to pay interest on the public debt be enacted to the Senate of the House of Representatives of the United States of America and Congress assembled, that for the purpose of the superintending the collection of internal duties, stamp duties, licenses, or taxes imposed by this act, or which may be hereafter imposed, and of assessing the same, and offices hereby created in the Treasury Department called the Office of Commissioner of Internal Revenue. Okay, so that's where the Commissioner of the Internal Revenue Service got created, right there. Section 4, and this other one was located at 12 Stat 432. This is 433 and 434, which is a page later. Section 4, be it further enacted that before any collector shall enter upon the duties of his office, he shall execute a bond. Section 8, that if any person owning, possessing, or having care of management of property, goods, wares, or merchandise, articles, or objects liable to pay any duty, tax, license, shall fail to make and exhibit a written list when required, as aforesaid, and shall consent to disclose the particulars of any and all the property, goods, wares, merchandise, articles, objects liable to pay any duty or tax, or any business or occupation liable to pay any license, as aforesaid. See, there was a bunch of things that was in this act. There was license fees too. Section 26, which is at 12 Stat 443, that each and every collector whose deputy who shall exercise to be guilty of any extortion or willful oppression under color of this act, that's where the Title 18 United States Code, Section 241 and 242 started coming into place, okay, violating somebody's rights under the color of law. Conspiracy to violate somebody's rights under the color of law. And then Section 86, salaries and pay of officers and persons in the service of the United States and passports. It's interesting that passports is separate from the service of the United States. Section 86, and be it further enacted that on and after the first day of August, 1862, there shall be levied, collected, and paid in all salaries of officers or payments to persons in the civil, military, naval, and other employment or service of the United States, including senators and representatives and delegates in Congress, when exceeding the rate of $600 per annum, a duty of 3% on the excess above the said $600. Okay, so again, this is income tax. Income duty, Section 89, be it further enacted that for the purpose of modifying and reenacting as hereinafter provided, so much of an act entitled an act to provide increased revenue for imports and pay interest on the public debt for other purposes, which is the previous one that we talked about, that some of it had been repealed. That is to say, it says approved August 5th of August 1861 as relates to income tax. That is to say, sections 4950, except so much there as relates to the selection and appointment of depositaries, and 51 B and the same are hereby repealed. This is what repealed those sections that I marked in the previous slides. Repealed. Section 90, and be it further enacted, there shall be levied, collected, paid annually upon the annually gains, profits, or income of every person residing in the United States, whether derived from any kind of property, rents, interest, dividends, salaries, or any profession, trade, employment, or vocation carried on in the United States or elsewhere, if such annual gains, profits, or income exceed the sum of, and that doesn't matter because it's changed today, if said income exceeds the sum of, and upon the annual gains of profits or income, rent, and dividends accruing upon any property, securities, and stock owned in the United States by any citizen of the United States residing abroad. That's where they tax Americans or U.S. citizens anywhere on the planet. And not in the employment of the government of the United States, there shall be levied, collected, and paid a duty. Section 118, and be it further enacted that whenever by this act any license, duty, or tax of any description has been imposed on any corporate body or property of any incorporated company, It shall be lawful for the Commissioner of the Internal Revenue to prescribe and determine in what districts such tax shall be assessed and collected, and to what officer thereof the official notices required in that behalf shall be given, and of whom payment of such tax shall be demanded. And this is why you get IRS letters from all over the USA, because that's what they do. They put you on the round robin. So this is and some historical stuff. A person is only a fictitious entity, and that's found at 16 Stat 431, which is approved on February 25th, 1871. This is the an act prescribing the form of enacting and resolving clauses of acts and resolutions of Congress and the rules of construction. Okay? And be it further enacted in all acts hereinafter passed that the word person may extend and be applied to bodies politic and corporate. So it is bodies politic and corporate. An act concerning the construction of statutes, which was approved January 2nd, 1852, by the Legislative Assembly of the Territory of New Mexico. And it goes on being enacted by the Legislative Assembly of the Territory of Mexico, New Mexico, that Section 1, that in the construction of the statutes of this territory, the following rules should be observed. 6, the word person may be extended to bodies, politic, and corporate. That's just about exactly how it says in the Federal Act. Chapter, let's see, that's 56. An act to provide a temporary government for the territory of Arizona and for other purposes, which is located at 12 Stat 664, together with all legislative enactments of the territory of New Mexico not inconsistent with the provisions of this act are hereby extended to and continue in force in the said territory of Arizona. So that basically makes the New Mexico stuff all applicable in Arizona. This is 26 U.S.C. 7701. When used in this title, were not otherwise distinctly expressed or manifestly incompatible with the intent thereof. The term, these liars like to put in all this stuff to get people confused. The term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. So, based on the law of justum generis, an individual is a fictitious entity, and based on the word includes and what the courts have said, then that's what you see written there is all there is. The words person and whoever include corporations, companies, associations, firms, partnerships, society, joint stock company, as well as individuals. An individual in this case is another fictitious entity. Person means an individual, firm, partnership, association, or corporation. Person includes a corporation or organization, government or governmental subdivision or agency, business, trust, estate, trust, partnership, association, or other legal entity. See, these are all include. Or the participial form thereof is designed to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve, and that's Montello Salt versus Utah. There's Noah English Dictionary of English Language by Noah Webster, 1828. Include is to confine within, to hold, to contain. As a shell of a nut includes a kernel, a pearl is included in the shell, but in these senses we more commonly use enclose. And then in Black's Law Dictionary, 6th edition, it basically says the same thing. State statutes are actually federal statutes. International law rule adopted for areas under federal legislative jurisdiction federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of a state. And this is taken from Jurisdiction over Federal Areas Within the States, report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the law of the legislative jurisdiction submitted to the Attorney General and transmitted to the President, June 1957. This is page 158. And then we go to page 165 of the same document, and it says, state and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws. And a cause arising under such laws may be brought in or removed to a federal district court, and it goes through and talks about it. Anyways, the point being is that state laws are actually federal laws, and here's why, right here. Okay, and actually there's a bunch of cases that talk about this. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia and through their plenary power. Nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948 U.S. Supreme Court. In other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. If a state is conformed to the new order, there is no need for Congress to intervene, and if a citizen has not obtained standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual under this clause. And this is Judge A.H. Ellett in this book called Non-Ratification of the 14th Amendment that's associated with the case Diet versus Turner. So the point being is that state laws are actually federal laws. It's all martial law. In this state, within this state, in this state, within this state, in all block capital letters, includes all federal areas lying within the external boundaries of the state. That's Revised Code of Washington. This is Texas Tax Code. In the state means within the exterior limits of Texas and includes all territory within these limits ceded to or owned by the United States. Well, I can tell you for a fact there's nothing been ceded to the United States. Now, whether the United States owns something or not, it's hard to say. I'm sure they at least rent the courthouses and the military bases. They may own them too. But it wasn't ceded. Economy, plumbing, and heating. Persons who are not taxpayers are not within the system and can obtain no benefit by following the procedures prescribed by taxpayers, such as the filing of claims for refunds. The revenue laws are a code or a system of regulation and tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither the subject nor the object of the revenue laws. This is D.C. Code. See, 1901, I think. It doesn't say here, but anyways. This is located at 31 Stat 1432, at Chapter 56, Section 1617, and it says the legal estate to be the cestui trust. Okay, and then the Congressional Record of June 13th, 1967, a summary of pages 15,641 through 15,646. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive cestui trust of U.S. Inc. under the 14th Amendment, which upholds the debt of USA and U.S. Inc. And Henry Boland says that every taxpayer is a cestui trust, having sufficient interest in preventing the abuse of the trust is recognized in the field of this court's prerogative jurisdiction. So U.S. citizens is a cestui trust. And this continues on the D.C. Code 1901, March 3rd, 1901. And in 31 Stat 1189, be it further enacted that interpretation of the construction of said code, the following rules shall be observed, namely, the word person shall be held to apply to partnerships and corporations, and they can presume that you're dead at Chapter 3, absence for 7 years, Section 252, presumption of death. If any person shall leave his domicile without any known intention of changing the same, and shall not return or be heard from for 7 years from the time of his so leaving, he shall be presumed to be dead. Well, this gave them the right, since all estates are titled under the cestui trust, this gave them the right to assume everybody's a cestui trust. That's exactly what it is. He shall be presumed to be dead, and in any case wherein his death shall come into question, unless proof be made that he was alive within that time. It might be correctly said that there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. This is Title 5, United States Code, Section 552. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. And in paragraph 13, it says the term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. So anybody with a Social Security number is federal personnel. Income taxes were originated by an act of Congress in 1861 for U.S. citizens. State statutes are actually U.S. statutes. If you use, or the bail priests in the so-called courts can presume that you used Federal Reserve notes to pay for anything, then it's not paid for. And now a little advertisement. Don't forget to subscribe to this channel. Don't forget to click the bell next to the subscriber button so you're notified when there's a new upload. And there's the front page of the channel, and there's an arrow pointing to the bell. So don't forget to click the bell, and then that way you'll be notified when there's an upload. Title 12, United States Code, Section 411. Back to the topic at hand. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to the Federal Reserve banks through the Federal Reserve agents, as hereinafter set forth, and for no other purpose are authorized. The said notes shall be obligations of the United States and shall be redeemable by all national and member banks, Federal Reserve banks, and for all taxes, customs, and other public duties. They shall be redeemed in lawful money on demand at the Treasury Department of the United States, in the city of Washington, District of Columbia, or at any Federal Reserve bank. So a Federal Reserve note is an IOU. Okay, it's not a promissory note. It's an IOU. There's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. Boy, these lawyers, these liars, just lay awake at night dreaming this stuff up. Federal Reserve banknotes and other notes constituting a part of the common currency of the country are recognized as good tender for money unless specifically objected to. Yes, you can object to them. Dollar, the legal currency of the United States, the unit of money consisting of 100 cents, the aggregate of specific coins which add up to $1. That's what a dollar is coins. In the absence of qualifying word, it cannot mean promissory notes, bonds, or other evidences of debt. Banknotes constitute a large and convenient part of the currency of our country and by common consent serve to the great extent for all purposes of coin. In themselves, they are not money, for they are not a legal tender. Well, they are now. They made them that way. And yet they are a good tender unless specifically objected to as being notes merely and not money. They subserve the purpose of money in the ordinary business of life by the mutual consent expressed or implied of the parties to a contract, and not by the binding force of any common usage, for the party to whom they have been tendered has an undoubted right to refuse accepting them as money. A banknote contract. A banknote resembles a common promissory note issued by a bank or corporation authorized to act as a bank. It is, in fact, a promissory note, but such notes are not, for many purposes, to be considered as mere securities for money, but are treated as money in the ordinary course of transactions of business, but by the general consent of mankind. Now, you have to understand, they must be here, 1856 edition, they got to be talking about the silver certificates or gold certificates, because otherwise there's no promise to pay. There has to be a promise to pay to be a promissory note. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They form a part of the public debt of the United States. Okay, so it's a forced loan of 1862 and 1863. That's talking about treasury notes, and it's an IOU. It's a loan is an IOU. Okay, if there's no promise to pay, it's an IOU. At common law, only gold or silver were legal tender, and this is Nesbitt, McLaren versus Nesbitt, South Carolina case, I believe, 1820. But they're citing Book 2 of the Institutes on the Laws of England by Coke, so that goes back like to 1500s. Juilliard versus Greenman, the forced loans. Actually, we read this one a minute ago, and we read that one a minute ago. A usufruct, the right of enjoying a thing, the property which is invested in another, and to draw from the same all the profit, utility, advantage which it may produce, provided it be without altering the substance of the thing. And that's Bouvier's Law Dictionary, 1856. A usufruct is a type of a trust. Prior to 1900, a trust was called a use, which is short for usufruct. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. And ecclesiastical means Roman cult. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that means the Roman cult, to be bound in conscience to account to a cestui use for the rents and emoluments of the estate. That sounds like taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And it is still the foundation of modern conveyancing. And now a little advertisement. Announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit. For that reason, there'll be very little exclusive material on that channel. I originally was planning on putting exclusive material, but I can't think of anything that I want on there exclusively. And so it'll just have the videos right now. If I come up with something, I'll put it on there. But in the meanwhile, the only advantage is going to be no advertising. So for $1.99, you get to skip all the ads. And you can make a donation if you want, $1.99 a month. Currently publishing 6 videos a week. Some people have had trouble finding the channel, so I put a link down there at the bottom. And if you go here, you can see the link is highlighted at the top. And don't send me a donation because I won't be able to sign you up for the channel. I cannot sign you up. You have to go through YouTube to do it. I'm sure they take a piece of the action, but the bottom line is that I don't have any power over that. And so I won't be able to sign you up. You'll have to go there and do it yourself. And start the free trial. And I don't know what exactly information they want, but yeah, that's what you'll have to do. Anyways, back to the topic at hand. Ecclesiastical courts equals admiralty. A citation is a summons to appear applied particularly to process in the spiritual court. The ecclesiastical courts proceed according to the course of civil and canon laws. Okay, and so by citation and libel and again admiralty, this is all part of canon law is where it is. This all goes back to the Roman cult. That's Tomlin's Law Dictionary 1835 edition, and then there's Black's Law Dictionary 2nd edition. Says the citation is also the name of process used in English ecclesiastical, probate, and divorce courts to call the defendant or respondent before them. And that is cited from Black's Law Dictionary 2nd edition, but they're citing Book 3 of Blackstone's commentaries and also Book 3 of Stephen's commentaries. A tax, an impost, a tribute exposed on the subject. An excise tallage. In public law, taxation signifies the system for raising money for public purposes by compelling the payment by individuals of sums of money called taxes. Some general principles of taxation have been said to be the subjects of every state ought to contribute to the support of the government as nearly as possible in proportion to their respective abilities. That is, in proportion to the revenue which they respectively enjoy. Revenue means corporate profits under the protection of the state. In the observation or neglect of this maxim consists of what is the inequality or equality or inequality of taxation. And that's taken from Smith, The Wealth of Nations, which is cited in the Dictionary of English Law, Sweet and Maxwell Limited, London, 1959. And so now we'll talk about zip codes. This is going to be taken from the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court, and this is related to the case Diet versus Turner. As we have said, the federal personal income tax is collected under a military venue within a martial law jurisdiction. Federal Reserve notes are military script circulated within a military venue. The problem is the people don't understand how the entire United States is covered by a military venue. Under the Social Security Act that was brought into existence, 10 federal regional areas. These 10 federal regional areas are the same as a military base. It is not unconstitutional to circulate military script on a military base as the base is considered to be a military venue. Military script cannot circulate in the civil jurisdiction of the several states. To get around this constitutional bar, the Congress, via the Social Security Act, created 10 military venues called federal regional areas. And it goes on. The problem the Congress realized was While Congress could restructure the government agencies into federal regional areas, the people could not be identified to be within this military venue, but by their own consent. The solution was to create another military venue which would trick the people to voluntarily accept recognition that they're in a military venue. Congress solved this problem by creating the zip code. The zip code divides the United States into 10 military venues called national areas. And it goes on, when a citizen received mails from an agency of the federal government, such as the IRS, and the return address of the federal agency is the district within the original area the letter is sent from, and on the address the citizen it was sent to is the national area in which he received the correspondence from the IRS. In other words, the correspondence was sent from one of the federal regional areas, a military venue, to one of the national areas, another military venue. Taxing districts were established within one of the federal regional areas, which places the collection of taxes under a martial law jurisdiction. Taxpayers are not state citizens. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. U.S. citizens are slaves. State citizens are we the people. The state citizen is immune from any and all government attacks and procedure absent contract. See Dred Scott versus Sanford. Or as the Supreme Court has stated clearly, every man is independent from all laws except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. The rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government. City of Dallas versus Mitchell. The people are sovereign and not bound by general words and statutes restrictive of prerogative right, title, or interest unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. And this is People versus Herkimer, New York Court Case 1825. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Chisholm versus Georgia. Lansing versus Smith. The people of a state are entitled to all the rights which formally belong to the king by his prerogative. So in any state, you have state citizens and federal citizens, two separate classes of people, and state citizens are untouchable. And so then it only applies to federal citizens. It will be admitted on all hands that with the exception of the powers granted to the states and the federal government through the constitutions, the people of the several states are unconditionally sovereign within their respective states. A sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's U.S. Supreme Court again. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence to the charter powers of the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Title 15, United States Code, Section 17, the labor of a human being is not a commodity or article of commerce. Why do you think they want to know your occupation? You could really tie them up in knots if you put yourself down as getting compensation for labor. Because almost everything is done these days with commercial paper. The Roman cult's courts presume that commercial paper was used. The cestui trust originates with the Roman cult. If it is the Roman cult that's stealing everything they can get their hands on, the Roman cult is trying to start World War III to reduce the population. Too many useless eaters. Everything they do is a fraud. Quit participating in their fraud, lies, and Satanism. It's fraud, and a fraud is a lie, and a lie is Satanism, and they're all cowards. Okay, that's what you got to understand. They're doing this in secret. They're slipping it over on you. They're cowards. They don't want to tell you what's going on. They're cowards. Once a fraud, always a fraud. Things invalid in the beginning cannot be made valid by some subsequent act. A thing void in the beginning does not become valid by lapse of time. Time cannot render valid an act void in its origin. These are Satanists, and they're all cowards. Out of fraud, no action arises, and any action by any government official to conceal a fraud becomes an act of fraud. It's a fraud to conceal a fraud. These are all maxims of law, and a fraud is inexcusable and unpardonable. Fraud and deceit should excuse no man. And these are Satanists, and it's all cowardice is what it is. They're trying to get you to participate so that they can justify the theft of your property, and they're not going to come out and tell you. They're cowards because they're perjuring their oath, and it's warfare is what it is. And any fraud amounts to injustice. Fraud and justice never dwell together. What is otherwise good and just, if sought by force or fraud, becomes bad and unjust. If you provided a Social Security number in dealing with any of these issues, then you provided evidence against yourself that you're a U.S. citizen, you're involved in interstate commerce, you're not entitled to an Article 3 court, you're not entitled to access to the first 8 amendments to the Constitution, you're a taxpayer. I don't know about you, but I don't have a Social Security number. It's a number for a cestui trust. You got to understand that. It's not my number. Watch my asset protection video if you want to learn about protecting property. If nothing is in the name of their cestui trust, and there's nothing for them to steal. Due to issues of fraudulent conveyance, the sooner you do something like this, the better. And another advertisement about my other videos. Bankster Thieves 1, 2, and 3, Churchianity Series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft. Martial laws here, do-it-yourself no income tax, do-it-yourself no sales tax, do-it-yourself traffic stop, do-it-yourself free mail, do-it-yourself kangaroo courts 1, 2, 3, and 4, and 5 now. But there's another way that you can deal with these taxes. All state taxes are for U.S. citizens, and so you can. There's a dissolve your debt manual. It's on my group in my files directory, and I've used that, so you can use that. Just download it from the group. With the A for V, you're using the acceptance for value procedure. You're essentially saying that you know that there's no money in the system and you're accepting it for value. You know they have no authority, but you're allowing them to set off the so-called debt against the cestui trust account. It's basically a gift, okay? And so when you were born, they created a cestui trust account, and that's what they're using. It's claimed that the Dissolve Your Debt Manual can be used to set off alleged debts to bankers for taxes of all kinds and for utilities. I know people that have used it for years, although most recently it's become more difficult because of the Satanist that was in the White House. Sometimes you're dealing with thieves and they try to get you to set it off several times by sending you additional invoices and so then they can charge it more than once. The bottom line is that never, ever, ever give up. All these state taxes are for U.S. citizens. They're not for state citizens. There's 2 classes of citizens in America. And don't ever give up, okay? What happens is you show intent. So the sooner you start showing intent, the better. And they'll go away and leave you alone. Anyways, copies of these documents can be found at my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. And this last paragraph is for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. Donations to support this work are appreciated, but they can put their privileges and benefits up their rectal orifice because I prefer a gold or silver coin. But as an extremely less desirable alternative, I can accept their IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living and also now Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group is called Sovereignty International, and I'm deleting that one. It takes a while to ban 17,000 people off of there because I don't want Facebook to be profiting from it. My Yahoo private group is called Administrating Your Public Servants, and my Google private group is called Administrating Your Public Servants. I appreciate you taking the time to watch the video. I hope you get something out of it. And, knowledge is power. You have no idea. You don't know who you are. Watch my video series. I got a playlist called that. So search on my YouTube channel for that playlist and watch the playlist because I think you don't know who you are. Most people do not know who they are. Anyways, I hope you have a real great day and thanks for watching.